Coming to the topic of today, which would be what is an effective way of drafting an arbitration agreement or a clause in a particular contract? What are the nuances and what are the advantages and disadvantages of putting a clause or drafting a clause in a particular contract? And I would be taking you through, and my endeavor throughout the webinar, at the end of the webinar, would be to see that uh, one of you can actually go and draft an arbitration clause in a particular agreement. Wherever possible, I have also laid down few judicial pronouncement on the subject matter wherever relevant, so as to ensure that every student and every gets a real perspective on what actually the courts and people are the courts have been holding in various jurisdictions and the courts in India. Now we all know why arbitration is the preferred mode, but just to give a little brief about arbitration. Now we know arbitration, we initially started in the year 1940. Eventually it went to the 96 Act, and thereafter there have been amendments in 2015, 2019, and the latest one being in 2020. Now, arbitration, as we know, has evolved throughout from the ages, and it has taken up with the times. And of course, knowing as the multinational companies and having an arbitration seat in India, so a lot of things has changed. Knowing with and keeping up pace with the law which is applicable worldwide. Now, of course, why arbitration is preferred? I think the answer is simple in that, to say that it is less time consuming, as in terms of a court proceeding. It is more cost effective at times. So, say for example, if you need to file a suit for particular, your court fees can go up to a maximum of say 3 lakh rupees, whereas in an arbitration, depending on the quantum, one can know that the arbitration is in a fixed mandate. Of course, the entire intention of an arbitration is called the party autonomy. Now, what is party autonomy? Is that you are not bound by the rules of a particular, let's say, the Evidence Act or the CPC, and the Arbitration Act specifically deals with that. I think the Section 19 deals with that, where we will particularly say that it does not bound by the CPC and the evidence rules. Let me first take you off what I'm going to cover in this particular session. As I said, it is the arbitration agreement. What is a test for identifying whether an arbitration is a subject matter is arbitrable or not arbitrable? Of course, matters, there are certain matters which are not arbitrable. What is your essentials of a valid arbitration agreement? So when I say essentials of a valid arbitration agreement, it would try covering all the aspect where one should try cover. Let me be very frank and straightforward on this. There is not a sample clause where one can put it. Every transaction will depend, and your arbitration clause will have to change based on the circumstances. So one cannot say that this is a boilerplate clause and this is where it has to come. In fact, on the contrary, if you do that, there are high risk or a high chances of you not being able to succeed in your arbitration, and you will the parties will actually suffer going forward, and there will be multiple litigation which will even increase your cost. Now, the fourth point, of course, I will be giving you certain tips in terms of drafting and effective arbitration clause, along with certain specimens where I have tried to endeavor, coupled with the judgments, with where a proper arbitration clause could be, or rather, it could be a suggestive clause. As I said, there is no straitjacket formula; it is only a suggestive clause, which I will take you through towards the end of the session. Now, coming to this, what exactly is an arbitration agreement? Now, an arbitration agreement is basically where parties submit to all the disputes in relation to their contract, which may have arisen or which are, of course, in future or which are even existing, whether contractual or not. Uh, an arbitration clause usually is one which is negotiated when, unlike your any other clause, let it be your indemnification, let it be your representations and warranties, let it be your notices, etc., any other clause, just like any other clause, this is a clause which is within your contract. Of course, arbitration agreement, let me tell you, is a separate agreement than from your main agreement. One can always have it embedded within the contract, or you can always have a separate agreement. But I think most of the times people have it within the contract or within the agreement itself. Um, of course, on a lighter note, arbitration clauses usually are, which it's a very famous term used, and I'm sure most of you all have heard it. It is called the midnight clauses. Now, when we say the midnight clauses, is because people are wanting to finish the transaction on a particular date for an XYZ reason, and eventually the parties do not focus on putting an effective arbitration clause, which of course releases. As I said, this is on a lighter note, where parties do not actually deal with it. But yes, there are situations where later the party realizes that we could have put in more in the arbitration clause. Now, of course, as I said, it is a different situation where parties, when they belong to a different jurisdictions, when there are two separate set of parties, of course, the criteria and the clause may become complex in that sense. When I say complex, it sometimes, to be honest, we are ourselves sometimes make it complex. It could really be kept easy depending on the various factors, as I said, about the agreement, even in terms of your enforcement. Sometimes it makes a difference that we realize that we put something in terms of the seat of the arbitration, or your law governing the arbitration agreement, whereas we realize that the assets of that particular company are actually not even located there, or your enforcement in terms of your execution of the award sometimes may become difficult. So these are certain factors where one may have to consider before putting in an effective, and that's why it's important, as I've mentioned, that it is important to determine the law which will govern the dispute and the arbitral proceedings. Now, very interestingly, what is your test to determine what is non-arbitrable? We all know everything, unlike, let me tell you an examples of arbitrability all over the other jurisdictions, let it be Singapore, UK. Most of the disputes are actually arbitrable, and they actually even go to extend to even they in terms of your fraud, where of course now India has taken a very proactive approach and has also said in the same judgment itself, in the Vijay Dolia judgment, where they say that the fraud aspect can be arbitrable. When I say fraud aspect, it of course will not involve something which has a criminality. And let's say the example which was there in terms of the Commonwealth Games, which happened in 2010. That was a major issue where, of course, there were certain arbitration issues in that, and the people had the agreement and they invoked. But the view in that is that these type of matters cannot actually be referred to arbitration, because it would always require the judicial overlooking or intervention in such matters. So, as mentioned in this, what is non-arbitrable? It is in relates to actions in rem. Now, let me first give a little this about rem and personam, as we understand, most of you all do know, but just to the people who don't, when actions in rem would mean it would mean at public at large, and personam, of course, would be an inter se agreement or inter se parties. Now, very interestingly, it says that certain disputes which are in, actually they relate to rem, but that they are not pertaining to the subordinate rights of rem. So let's say, let me give a very simple example on this, which I also mentioned in the slide, is the example of a trademark. Now, when I say in a trademark dispute, and when there is an arbitration agreement of a, let's say, in a trademark license, and there is a dispute between party A and party B in terms of non-payment of the license fee. It could be after the agreement is over, that the party is continuing to use a particular mark despite termination, and there are certain, let's say in a franchise agreement, there are multiple things what a franchisee will have to actually adhere to, and the franchisor will have a right to terminate on these clauses. So in this case, what the courts have held is that this would be arbitrable because they are subordinate rights to a right in rem. So because public being in rem, where a trademark, so let's say your trademark infringement will not come under the domain of an arbitration, but breaches under those license agreements will be very well arbitrable. The second is in terms of the third party rights, and which require centralized adjudication. Now, again, in this case, I think the simple answer to the question the example I have mentioned is in terms of your insolvency matters. So let's say that there are certain like winding up days also, where in the times of the Haryana Telecom judgment, where they say that the winding up is something where even if the parties have an arbitration, the arbitrator would not be able to decide, for the simple reason is because they will be actually disputes in rem. Rem again being because it is affecting public at large. So let's say a company today goes into insolvency under the IBC. Once it's admitted, it is actually an action in rem. It no longer becomes in personam, because every creditor of the company would like to file its claim and etc. and go ahead with the proceeding. The third is in terms of the public functions of a state. Now, mostly on these terms is the criminal offenses, which happens against the state, and that the the law settled by the Supreme Court recently is very clear that these criminal offenses, again, it should not be confused in terms of fraud relation to a particular contract, but these are serious criminal offenses. When I say it could be murder, it could be robbery, it could be anything with a serious criminal offenses, that is not to be referred to arbitration. And of course, the last being that the subject matter is expressly and impliedly barred by a particular statute. Now, what do you mean expressly or impliedly barred by a particular statute? It would mean that, let's say, again, the example which I mentioned is the industrial dispute and your tax disputes. There is a particular forum where one can adjudicate their disputes, and they need not go in actually for an arbitration. And arbitration would be exactly barred, because a lot of people actually do not see the Arbitration Act, but the Arbitration Act itself says that something, if this act is in derogation with any other law, that law will actually prevail. So in this sense, that when there is a specific statute where an arbitration is barred, we will not, the parties cannot relate to arbitration. Now, giving a few examples of what cannot be referred to arbitration, and this has been held just for the viewers, be giving few name of judgments, like in terms of Booz Allen, where there were certain matters, in fact, Booz Allen and even the Vijay Dhulia, which I mentioned in the earlier slide, they both relate to certain kind of matters where the thing is not, where the subject matter is not arbitrary. Whether it is because all this will turn in terms of rem. So it's your insolvency matters, your guardianship, your trust disputes. Trust disputes is another issue which cropped up, in the Supreme Court, where they said that the trust disputes are actually not arbitrable. This again is quite an issue which again derails the entire arbitration and the pro-arbitration approach what the courts have took. But in this, they took a little conservative view and held that the trust dispute should actually not be arbitrable, and it should be before the civil courts. Again, I said the criminal cases, the matrimonial disputes, so testamentary matters, where there is terms of challenging a will and etc. All this will go before a court and not before before the arbitration. Your industrial disputes and tax, as I mentioned. Now, what do you say by essentials of an arbitration agreement? How do you deter and how do you determine that, yes, this is what I need and this is what it could be an essential of a valid arbitration agreement? It should be in writing. First and foremost is that an arbitration agreement has to be it has to be in writing. The arbitration agreement will also concur if it is signed by the party. Again, when I say signed by the parties, the courts have taken a lot of times a view that even if the agreement is not signed by a party, but if the intention, which I'll be coming a little later to the slide, where the intention of the party is clear, the matter can be referred to arbitration. Of course, the second being that there could be exchange of letters, telegrams, and other means of communication. And of course, the latest, where the amendment was made in 2015, 2016, where they added the word through electronic means. Now, this electronic means gains a little importance when I'll come to my next slide, where by email an arbitration agreement was exchanged. It was held to be a valid arbitration agreement, and parties were delegated to arbitration. Now, it would also mean an exchange of a statement of claim and defense, where the existence is not denied by the other party. So let's say if I file the statement of claim and where there is an arbitration clause and the other party does not dispute it, it would be well taken by the arbitral tribunal that there is a valid arbitration agreement. Now, another way of saying that what is where an arbitration agreement would be in essential is terms of a reference in a contract, which is to a document containing an arbitration agreement. So let's say party A and party B have already entered into a document, and in terms of, let's say, an MOU or any such nomenclature of the document, and the parties thereafter enter into a subsequent agreement. Now, parties, instead of in the subsequent agreement, do not want to put in a specific a clause to that particular or arbitration clause. They may simply refer it and incorporate the clause which they had in the earlier by just referring that the clause of the arbitration is incorporated by reference, and it would be applicable to this case. This also sometimes become important in terms of multi-party agreements. So here are a few judgments which I thought is a little relevant in terms of when I say about the essentials of the arbitration. The first judgment being of the Inox Wind, where the Supreme Court said that was dealing with an issue whether the arbitration clause in a purchase order would it be a valid arbitration agreement because it was annexed to the terms and conditions. Of course, it was not signed, but it was annexed to the purchase order, and of course the parties acted upon it. So, and it was a general reference to a standard form of a purchase order. So the Supreme Court was very clear that yes, this would amount to an arbitration clause. In fact, here I may also give a little practical this thing where we were dealing with a particular matter, rather, in fact, two matters on a similar lines, where we actually we were for the claimant and we were arguing that there is a valid arbitration agreement. This was way back 5-6 years back, where we were dealing with a similar aspect when we said that our purchase order had rather in our case, I think it was the invoice which had the terms and conditions, and it was on the reverse of the invoice. And of course, the other side had the issue of saying that no, this is not an valid arbitration agreement because it is not signed, it is not acted upon, and the normal defenses of a respondent to not get into an arbitration and relegate to a normal suit. Of course, we were successful in terms of defending, and we faced various challenges, and I think it went right up to the Supreme Court also, and eventually it was decided in our favor. So that was in terms of where it's a settled proposition that in terms of a purchase order, yes, there have been few judicial pronouncements where, especially the Delhi High Court, seems to take a little more technical approach in terms of this, but I think by and large, most of the courts have taken a view that it would amount to a valid arbitration agreement. Going by the second judgment is the Galaxy Infra. The Delhi High Court in this case dealt with an issue where the exchange, which I was mentioning in my earlier side, where there was exchange of the arbitration agreement by email would amount to a valid arbitration, and it would squarely fall under the ambit of an arbitration agreement. Now, coming to intention of the parties. Now, when you say intention of the parties, how does one figure out the intention of the parties? Of course, this will have to be when you read your agreement as it stands, that whether the parties would want to arbitrate or not arbitrate. This is something of a prime importance given by various judgments of the Supreme Court also and other high courts, where they say that the intention to refer it is very important. And so one aspect where I would like to give in terms of when you draft a particular arbitration, as I've mentioned, one can avoid using the terms, as I've said, that if during the continuance of the agreement or at any time afterwards, parties may refer it, or if the party so determines, if or one can always avoid using this because the intention of the clause may not be interpreted well by the court or the arbitrary tribunal as the case may be. So the better way to put it is that yes, parties shall resolve the dispute by arbitration and then governed by so and so and so and so laws as the case may be. A very interesting judgment, which is of the Visa International and the Supreme Court, where I think this is in the Vanota, where she mentioned about that no party should actually, take advantage of such drafting and wriggle out of your obligation, or rather of a party where it would want to refer it to arbitration. Uh, One can always read this judgment quite interesting in terms of, again, it talks about the intention of the parties. Um, I have often seen this in terms of referring, and in fact, a couple of cases where we had actually had the opportunity to see this particular agreement. Uh, Please and please, when you draft the arbitration agreement, when you say that eventually if a party has to refer it to, and there is a considerable difference between shall and may, as I mentioned earlier, please see that all your reference is made to say that, because as you know that the former, when I say shall, is something which is mandatory, and the latter can only be an optional one. So one can't say, and the example which I have given in the judgment was quite interesting again, which was in the quick heal technology, where the court actually went on, and I think it was Justice Kadawala who dealt with this issue, where he said that the parties have mentioned about the, in case of dispute, the parties may refer it to arbitration. Now, the entire question of the intention, again, this is where I read intention and unambiguous and the clear terms in an arbitration agreement. When you deal with both, the court was of the opinion, after looking at the entire thing, that you yourself have not mentioned that you would want to refer. In fact, in one of the other, in some of the other matters, I have also seen that people will refer it may, or they will say, or refer it to courts at so and so, at Mumbai, Delhi, etc., as it may be. Again, we are quite vague here. We are not clear in terms of putting that the arbitration, the party shall refer it to arbitration, and matter has to be resolved by an arbitration. So as far as possible, do not use the words may, if, or, as I said, even in the earlier one, because the intention is of paramount importance in any arbitration agreement. Coming to scope, now, what does one do in terms of scope of an arbitration clause? When I say scope, what does one in generally means of a scope of an arbitration? Because I said arbitration in the clause itself is a separate agreement, separability from its main. When I say that parties have to refer, and I say that disputes in relation to a particular agreement shall be referred, I may be limiting my scope in the arbitration agreement. So rather, the better way of putting it is that any or all such disputes arising out of and in relation to, or arising out of or in connection with. What this basically does is, and this will also be helpful in terms of dragging your, sometimes your non-signatories and your incorporation of reference, when I gave up the arbitration agreement, possibly even dragging them to the arbitration may be helpful. As I said, it's not that this is the set thing, but over the years I have seen that where parties have explicitly held this and have mentioned in their agreement, I think it's a more smoother way of your arbitration, and the arbitral tribunal takes a very view, which is that yes, all your disputes arising out of and in relation. So let's say an example of your MOU in terms of your termination, and it could be breaches under the other agreement. So what you're doing is you're saying arising out of and in relation to, and you're increasing your bandwidth in terms of getting everything under the arbitration agreement and under one umbrella. Quite often, and in some of the ones also, I have seen that in especially in your construction and some of these agreements, there are times where, if, because these are all happening in terms of your in-house drafting in these big construction companies, they sometimes want to limit a particular dispute. So as the example I gave in terms of quality work, maybe they do not want the arbitrator to decide this because they feel this is their domain, and it may be appointed by an independent expert. So this dispute cannot be arbitrable. Again, as I said, I have seen it in a couple of agreements where they would like to restrict it. So of course that remains outside the domain of a arbitration dispute. Nothing wrong if you do not put it, nothing right if you do not put it, but the construction companies usually look at it because they want their independent expert to have a particular view in this and not the arbitrator. Maybe a reason for that, because you don't know who your arbitrator is an expert in that particular field or does not know anything about the infrastructure or the construction area. These are some of the basic in terms of what one should add in terms of your arbitration in the clause. That is your number of arbitrators, your professional background, and of course your nationality, if it may be. Again, when I say in a general clause, these are only add-ons to a particular arbitration clause. One may put it, not put it, but there are certain times that one should be very clear in terms of, at least in the terms of your number of your arbitrators. And in case if it is a very technical matter in terms of, let's say, if it's an engineering and you require a person who would have the engineering background, you would want to put his or her expertise in this particular thing. Possibly a caveat here that assuming you choose the institutional rules of arbitration, let's say the LCI or the MAC or any other such institution, assuming that one party does not put, or both the parties do not put anything in terms of your expertise, the institutional rules are so robust in nature that they would actually be able to give you that particular arbitrator who actually has the expertise in this once one of the parties invoke the arbitration. Maybe that's one of the another benefit as I see it in terms of the institutional arbitration. So let your number of arbitrators be odd. Of course, even one will have in terms of you will not have, and you'll have not a breakthrough in terms of, you'll have a tie in terms of the arbitration. Of course, if one does not mention, and one would say that if you're governed by the Indian Arbitration Act, and you say that it is governed by the Indian Arbitration Act, and you do not mention anything about the arbitrators, I think Section 10, if I recollect correctly, would say that it was by default you would be entitled to a sole arbitrator, unless of course it is agreed otherwise. Now, as I said that there are times that you may add the qualifications not. I think another important aspect where one can put in the arbitrators or the number of arbitrators is something where, let's say, it's a very small dispute in terms of again, the dispute could be of, let's say, the purchase of goods, and it's a dispute which will not involve a lot of complexity. It is quite advisable, and of course, looking at the quantum of your invoice and purchase order, one may consider putting it in terms of having a sole arbitrator. Now, one may ask that what are the benefits of having a sole and a tribunal? Again, the straight or the two straight answers to that is the cost in terms of your having a 3 arbitral tribunal and having a sole. And of course, in terms of not getting time, because if it's a 3 arbitral tribunal, to get dates of 3 different arbitrators sometimes becomes a little tedious. Of course, during these virtual times, it may become easier, but on a normal parlance, I think sometimes it's very difficult to get all 3 on the same table. Now, as I said, if the number of arbitrators not mentioned, one can always, the institutions can, depending on your particular dispute amount, they can always refer it. There is another way to look at it that I have seen that one may also consider putting it in the arbitration clause itself, that assuming your dispute is to an X amount, you would have a sole arbitrator. If it's not a sole arbitrator and your amount goes to, let's say, X or Y, X plus Y, in that case, I would prefer it to have it to a 3 arbitrators. Of course, as I said, this is not a sole right. It is always has to happen with the parties' consent, and at the time of negotiations, when you put it in your arbitration agreement. Another important aspect which had cropped up during the last few years is in terms of the unilateral appointment of arbitrators. Now, all these things which I have called out is all from the judgments, where starting from your Perkins judgment of the Supreme Court, the TGF judgment of the Supreme Court, and even the latest one being of Light Bite Foods, if I recollect the name correctly, of Justice Patel, where all these 4 things have been embedded to say that a unilateral appointment of an arbitrator is not permissible. Now, what do I say unilateral appointment? most of the people must have seen, or rather, in your government contracts and in your public sector units, that they always say that okay, an ex-MD of the company or ex-employee of the company would be the one who would be deciding the dispute between the parties in the event the parties have to go for arbitration. So what these four judgments say very clearly, that an officer or an employee of the one party cannot be the arbitrator. Um, of course, where there is also situations where there are three arbitral tribunal, and they say that okay, if you do not appoint it from a sole arbitrator, why don't you appoint it from, let's say, from a couple of people, let's say the ex-MD or the MD or the employee of the company. Again, the Supreme Court and the High Courts have held that this cannot be a panel which is quite narrow based. Assuming even if you have to give them an option, it's got to be a broad-based, arbitrators, or the list of, or the panel which needs to be shared with the with the other side. And as I said, that in fact, in the construction contracts and in these PSU contracts, sometimes now post this judgment, what parties have actually started doing is either referring it to an institution, or to have it in terms of your normal arbitration act and not having it a unilateral appointment. Or possibly what they do is, to cover and to come under this ambit of these few judgments, they give you a very broad-based panel which will entitle you, then you can appoint a particular arbitrator from that. Now, it also, these judgments also say that if an employee himself is not entitled to appoint the arbitrator, he himself, because he is barred to appoint an arbitrator, he himself can't be an arbitrator. That's, as I said in the point number one. Even he would not be entitled to appoint an arbitrator going forward. If he himself is disqualified, he himself cannot appoint another arbitrator. So one should avoid in these types of this party should be careful of not appointing a unilateral appointment of an arbitrator. Now coming to the aspect of an international arbitration. Now, international arbitration, as we see, of course, international arbitration, one can have a seat in India. Parties are free to even go outside the country and arbitrate. This will purely depend, as I said again, on the party autonomy, which entitles anybody to have the dispute settled through any of the laws. It is permissible. What are the three laws which is usually governing the arbitration? Is a law governing the contract. Now, what is a law governing the contract? Examples I've given it is, if you're assuming that the Indian laws are governing, they would be the Contract Act, or they would be the Singapore Arbitration, the Contract Act, as the case may be. What would then be, you would calling your law governing the Arbitration Agreement? Now, again, here it would be your Arbitration Act 96 as amended, or your Singapore Arbitration Act, again, as the case may be. The third, which is sometimes there in your international arbitration, which mostly I have seen that yes, they are the ones which are the procedural rules, which I mentioned in terms of your MEAC, your CAC, your LCI, your ICC. All, of course, I think major of the rules by and large deal, the sum and substance is almost the same. Of course, every rule tries to match up to in terms of the current situation. Like the simple example of virtual hearings. Now, there are certain rules which have been amended now to say even virtual hearings are actually embodied in this in the particular rule. So the rules in that sense are, as I said, and as I mentioned earlier, they are quite robust. And if one asks from a personal point of view, I would always suggest to include institutional rules, because that will govern your particular arbitration, and you know that you need to complete a particular arbitration in the next point of time. Of course, I'll be dealing it a little ahead and explaining you the advantages also. Again, debatable. Most of the people must have heard this seat venue, seat place, and I think this saga doesn't seem to end anywhere. In terms of what would be the seat, what would be the venue. So, of course, our Indian law recognizes this, or having a juridical seat of an arbitration. Now, what the courts in India have also held, that once you declare the seat of arbitration to be X, that courts will have particular jurisdiction, and the laws of that particular would govern the arbitration agreement. Now, let's say if my seat of arbitration is Mumbai. Now I know that if I have managed to put Indian laws of my in the contract or no, I would be bound by the Indian Arbitration Act, because unless of course there is a contrary intention appearing in the clause, but I would be strictly bound by then saying that yes, the seat of arbitration is X, which is akin to a jurisdiction as decided in multiple judgments of the Supreme Court. Of course, it is very important when there is a situation where people do not use the word seat. What happens in that situation is people then try to use the word venue. It is perfectly fine that one may use the word as venue. But the only issue here is, or the only difficulty which may arise is that if the parties use seat and venue interchangeably. It's absolutely fine to say that the seat of arbitration would be, as I give the example in a domestic in terms of Mumbai. And I may say for convenience, if I put it very clearly in the terms of the agreement, that for convenience, I'm having my arbitration in, let's say, Delhi, Chennai, or wherever my particular party is. It is purely convenience. I am not shifting anything from a particular seat. So if that is mentioned, that is absolutely fine. But what if one doesn't mention the seat and only mentions the venue and does not have any other thing to support that particular clause? In that case, your venue would then be termed as a seat, which is also being held in the case of BGS Soma. If again I recollect correctly, it is the BGS Soma case where the Supreme Court has actually dealt with this issue. I think the challenge which also arises is that what happens if the parties have to select, let's say, your institutional rules, and the parties have not mentioned anything about the seat and venue? What happens in that situation? Well, in that situation, if you say the example I gave of ICC rules or your CAC rules, and you only say that yes, parties in case of any dispute will be referred to arbitration and it will be governed by ICC or CAC. That's it. You do not. Your intention is clear. You want to arbitrate. You know which rules you are governed by. So you're very clear on that. But what is not clear is what would become your seat of arbitration in this case, or rather, what would become your venue? Because assuming both are not mentioned, well, in that case, the again going by the judgments and the various pronouncements on this, that they are very clear that the default of that institutional rule. So let's say ICC, it would be London, which would be taken as your seat of arbitration. If it's SEAC and it's Singapore or various other in terms of would be taken as your seat of arbitration. So it is very important to mention this particular and do not use this interchangeably. Again, this must have been in terms of the two Indian parties. Again, I call it a very saga which is on right from the days of TDM infrastructure and earlier, and then the Sasan power by Madhya Pradesh High Court, and eventually now by the Supreme Court, where it has categorically and squarely said that yes, two Indian parties can go outside the country and would want to have a foreign seat of arbitration. Now, when I say foreign seat of arbitration, it would also naturally then mean that the award which eventually comes for enforcement in India, it would be under the Part 2, and then, so the enforcement would lie under 48 of the Arbitration Act. Now, why these two Indian parties had a lot of debate and discussions, because there are certain jurisdictions where parties are actually not allowed to. There are a couple of jurisdictions of my immediate recollection. I don't know the exact jurisdictions, but yes, there are a couple of jurisdictions, or rather 3-4, where they specifically say that their parties of the country cannot leave their particular country and have an arbitration outside the country. So by this, your two Indian parties who are incorporated in India feel that they don't want to get, they don't want to be governed by the Indian laws, can perfectly go to Singapore, London, Dubai, wherever they feel appropriate, and would want to adopt their rules and their laws. And of course, once the parties select that seat, as I mentioned earlier, and the laws, then they are strictly bound by the various procedures. So once the arbitration is completed, whether they want to challenge the particular award, whether they want to appeal a particular award, or whether there is anything in terms of the arbitration proceedings, nothing will then happen in India. It will all be taken outside India. What will only happen in India is your enforcement proceedings when assuming your award is in favor and you want to come to enforce it. Another important aspect here could be in terms of your having a reciprocating territory. Now, there are times that an award could be from a place where it could not be from a reciprocating territory. Of course, then your natural thing, natural corollary to that would be you would maybe prefer to have to file a suit and not an enforcement, which is a quicker process. So, though Indian parties are now being given that option, they have to be careful in terms of having their particular dilemma on which jurisdiction or which law to be chosen. Again, very clear that two Indian parties having a foreign seat does not debar them of coming and providing a Section 9 proceedings, which is for an interim relief in the local courts. Because that's how the Arbitration Act has been amended in 2015 to say that even if it's an international commercial arbitration and seated, of course, outside India, parties will have a right to come and seek interim reliefs. So that is also still open from the Indian parties. It's not that they are completely. Exception being, if you are excluding it, the part one of the year, of course, that exception will always stand. Again, I think I've dealt with in terms of the procedural law governing the arbitral proceedings and your institution versus your ad hoc. One can always have a different procedure in terms of deciding your particular arbitral proceedings. Of course, one has to bear in mind that there should not be any conflict in terms of deciding an arbitration governing the arbitration proceeding. Well, here again, language. Now, one may say that language may or may not be important. Whilst I'll agree that language may or may not be important, but at times in the international arbitrations, there is a situation that a universal language has not been put in terms of your arbitration agreement. And then it would then just derail a little process of the arbitration of once the parties have a successful award. It would actually be in a dilemma. The example I gave is in terms of one party being from China, another being from Russia. And imagine your arbitrator, imagine the arbitrator is from UK or from any other jurisdiction. It would really create a little chaotic situation in terms of the award being passed, because there would be a discomfort if the parties are actually not being able to come to a common universal language, which would be English in this case. So advisable that your language in the arbitral proceedings should mention that it's a universal language, assuming you have a multilingual proceedings and you have a Russian, Chinese, and different other jurisdictions or different people. It is always advisable to have the language. Again, no hard and fast rule that one does not put it, cannot put it later at the time of when the arbitration begins and says that I want to put it now. There is no such restriction if you got to put it, but if you put it, it's only advisable. Now, this in terms of when one enters in terms of multi-party agreements. Now, when I say multi-party agreements with different parties, when I started in terms of my earlier slide, I told you about in terms of arising out of and in relation to a particular clause. Now, in this case, of course, if a clause is added in terms of an incorporation, there could be a situation where you have an interlinkage of a particular agreement with and having a bearing on the dispute. The straight example I can give in terms of in a multi-party agreement, and where we can say the various judgments which are starting again from Chiran Properties, I think, and where the Supreme Court had to decide, and of course your chloro controls, where there were multi-parties. Of course, these were all international commercial arbitrations, but the Supreme Court, I think, in Amir Lalchand, had actually dwelled upon an issue in a domestic arbitration, and they said that yes, there seems to be linkage in terms of your various agreements entered, and eventually parties were referred to arbitration in that case. So it is always better that your arbitration clauses to be incorporated in a proper and fashion where, as I mentioned earlier, in terms of your incorporation in different contracts, so as to have a commonality of the subject and consolidating your arbitral proceeding. Coming to a multi-tier arbitration. Now, one may first just ask, what is your multi-tier arbitration? Maybe it's a common name, which these days it's a MEDAP, the MEDAP arbitrations, which is basically a mediation and an arbitration. clause in a particular. So what are these MEDA? So there are two types of mediation or multi-tier arbitration, or the MEDA clauses, if you may call it. Is that in the clause itself, one will have to put in terms of your mediation. So let's say if the dispute arises between the parties, the disputes cannot be resolved between the next days, if assuming that the matter does not get into any kind of a settlement, the matter would be then referred to an arbitration with whatever procedural laws and etc. etc. This in that case is a multi-tier arbitration clause where you first have your mediation and thereafter you have your arbitration. Well, it's a quote from a very famous this where they said that if you've not tried the mediation, you may actually suffer huge losses in terms of your litigation. Hence, the mediation arbitration, the multi-tier arbitration comes from that particular saying where they say that you need to mediate before you actually go in. In fact, our own Arbitration Act, I think 30 or 31, 30, I think, which deals with the aspect of that party should, the arbitral tribunal should also encourage settlement before actually going into arbitration. Now, the difficulty here in terms of these mediation arbitration clauses is what often seen. Of course, some courts take the view that there is a mediation arbitration clause, and you fail or you do not invoke, and you come straight by arbitration. Fair enough, you do not want it to do. But there are certain courts who have taken the view that if you do not invoke that particular mediation clause before you come for an arbitration, you are actually not abiding by the clause or the arbitration, the agreement in that sense, which parties actually entered into, which actually can be sometimes now the same, as I said, for the mediation, just like your Commercial Court Act, where under the provisions of the Commercial Court Act, your compulsory mediation is something which is important before a suit is filed. One may look at it again that is not mandatory and is directory. But I think this clause in that sense, one should try to put it in their arbitration agreements. And as far as possible, one should also adhere to that so that to avoid any issue later in terms of from the other party, so as in terms of having a dispute and then prolonging the litigation. Another important and interesting, I would say, again, is in this judgment of Centro Minerals, where the Supreme Court actually enforced an award. It's a foreign award. And in terms of these two-tier arbitrations. Now, when I say two-tier arbitrations, it was that it was to be decided first to be settled in India as per the Indian, and your appeal, unlike your appeal in terms of if you challenge the award, your appeal actually would lie before the ICC. Very interesting, because Justice Nariman in this judgment clearly says that it is again your party autonomy and everything which he deals with. He says that what is wrong in that clause, because you are giving an opportunity to challenge your award in the second tier of your arbitration, which is perfectly valid. And he went ahead and enforced the foreign award. Again, as I was mentioning about this Amit Lalchand case in terms of your binding and enforcement vis-a-vis third parties. Well, to give you a little brief background in terms of whether your arbitration third parties would be dragged into arbitration or no, I think the law in our country still is at least in terms of the arbitration is still in terms of it's a situation where certain times parties are referred to arbitration, certain times not. Now, as far as the Section 9 is concerned, I think the law is by and large settled that if it's for an interim relief, one can drag the third parties to the arbitration and having a Section 9. Now, of course, as the law in different countries, let's say if it's the Singapore and again if it's the UK, the law in that sense is that yes, they drag in those third parties to an arbitration. Of course, there are certain principles of your group companies doctrine, your alter ego, commonality of a subject is very important, and it would also bind the non-signatory to a particular. In fact, in India, as I said, the example I was giving of Cheran Properties and the Amit Lalchand case, where the connection between the dispute was shown, and actually the Supreme Court went ahead and joined the parties to the arbitration agreement. after the 2015 and 16 amendment of the arbitration, where your section 8, which is section 8, is basically where it's a power to a judicial authority to refer a matter to an arbitration. Now, let's say if it's a pending suit in between a civil court, what happens is that one party files the suit without realizing that, or without knowing, or with a deliberate attempt that there is no arbitration, and files a suit. What does the other party do is he files a section 8 application so as to say that, sorry, this cannot be before this forum, you have to refer it to arbitrator. Now, an interesting thing which happened during this in the amendments was that they said that any party claiming through and under. So let's say again, this claiming through and under went through again a lot of again saga, I would say, in terms of from your initial time, the few judgments which eventually led to the amendment, where even in the Law Commission report, the idea was to even amend the definition of party and include even a third party or a non-signatory. Whereas, of course, eventually when the amendment happened, the party word was not amended to that aspect, and it was only in terms of the section 8 which was there. But in Cheran Properties and in Amit Lachand and various other judgments, where the court has actually inferred and said that no, I think the idea is to even bind the non-signatories. Of course, as I said, the example of the group companies doctrine, the alter ego, and everything. The greatest example, again, the recent one, which everybody must be aware, is the Amazon future case, where actually the group companies doctrine is, and because the rules were of SEAC, they went ahead and even joined the non-signatories to that particular arbitration. Again, what one may see in terms of pre-deposit in a particular claim. Now, this is again a judgment of ICOM Delhi in Punjab state, where the arbitration clause had put in a very a clause in the sense to say that if you invoke the arbitration, and provided that the party does invoke, he will have to deposit a 10% of the amount he is claimed. Now, what the court and the Supreme Court actually went and said that this clause would actually be very arbitrary in nature. Of course, the money would be refunded back, and that was a different story. But the entire clause itself said that subject to this, that I will have to deposit it and you invoke it. Going on the intention of the arbitration clause, I think the Supreme Court was that this is very arbitrary in nature. So if one needs to put this, bear in mind that you do not put such clauses in terms of asking a pre-deposit in a particular arbitration clause. So here I have just tried to make a specimen of an ad hoc arbitration clause, where I have just given, and as I repeat, that this is only in terms of giving a guidance in terms of the arbitration clause. It is not that it's a standard, and because we don't have it under the arbitration agreement, that we have a standard format in terms of putting an arbitration. It will purely depend on your transaction and your agreement. Now, what does it say is that you say that any claim, dispute, or difference, including any question regarding its existence, validity, or termination, relating to or arising out of in relation to this agreement, shall be referred to a mutually appointed sole arbitrator, as may be in accordance with the Arbitration Conciliation Act 96, or any statutory modification, and may be amended. Now, you must be all wondering that the statutory modification and may be amended is also kind of highlighted. Now, the reason for this is in terms of, again, a judgment of the Bombay High Court, which can't immediately recollect, but it's maybe a couple of years, and I can get back to you on this. That where the courts actually held that if you do not put the terms, and if the parties wanted that any of your modifications, so let's give a straight example of, let's say, the 36 or 34, which is amended now in 2015, which says that there cannot be an automatic stay of the arbitral award, and you need to specifically ask for a stay. So the parties argued that by virtue of me putting in or any statutory modification, or as may be amended, what it does is it takes into ambit that whether it's 96, it's 2015, 2019, 2022, 2023, at every given point of time, I would be bound by any of the amendments which take place. So that is the idea of putting or any statutory modification, as it may be. Now, as I've also mentioned earlier, in terms of your low value contracts, as I said, you should ideally be having a sole arbitrator, and you can also prefer, which is very useful at times, is your 29B, which is your fast track procedure under the under the Arbitration Act 96. Now, usually these fast track procedures are actually the ones where they will call for submissions, the arbitrator, and he would ensure that you finish all your pleadings and everything. There may or may not be a oral hearing, but I think knowing the parties in India and knowing everybody, they would always ask for at least a hearing or two. Uh, but it's quite quicker in the sense that in terms of you actually not having to lead a lot of evidence, and you put your case in a concise. Again, this could be very relevant in terms of the sale and sale and purchase of goods, maybe, and your value or your contract value is not more than few lakhs. This is quite advisable because it will immediately entitle you to decide the dispute quickly, cost effective, as I said, and parties would be coming out with the proper, instead of going for litigation or let's say even going for a summary suit. This would be sometime even more advisable and flexible. Another important, I would rather put it important, is that what do you do in terms of your rules of evidence? Because as I mentioned earlier, that you do not have a strict, you're not bound by the CPC and the Evidence Act in the Arbitration Act. But I have often seen that, especially in the international arbitrations, one may refer to the IBA rules. Now, what is the IBA rule? It is your International Bar Association rules. Now, these rules are basically on evidence. Now, what it basically does is it would tell you the way you are going to function in terms of your document production. It would tell you how you're going to appoint your independent experts in evidence. How are you going to deal with your evidence affidavits? A very crucial aspect in this, which I have practically also noticed, is the concept here is, and they use in the IBAs, is a reply to an examination, to the evidence affidavit. Now, what do you mean a reply to an evidence? We know, we all are aware that in India we file the affidavit in lieu of examination in chief. But what happens in this case is it's a reply to an evidence. So I put my evidence and I say that yes, an X fact has happened on an X particular date, the format which is already there in terms of the IBA rules. What I do is I counter it by a particular my fact. It's a fact versus a fact, because an evidence would be led in terms of the fact, and I would put the perspective in the right perspective in picture. Now, what is the benefit of this? Well, the benefit is that once the pleadings are complete, your evidence is done, you start with your opening submissions. What this does is your cross examination in terms of the evidence is actually curtailed, because I have put my evidence, you've put your version. Of course, there are the cross examination and you can ask other questions. But what it will basically do is it will try to shorten your process in terms of your arbitration. And I have personally experienced this in an international arbitration also. In domestic arbitration, I would also say that one may look at the IAF rules. Now, these IAF rules is something which is known as the Indian Arbitration Forum rules. Not widely circulated with a lot of passion, but there have been, in fact, they have come up with their version 2 sometime last year, where they actually would give, in an ad hoc arbitration, I would really recommend that one may put these particular IAF rules, because it will give an arbitrator or a sole arbitrator to deal with a particular, of course, if it's not an institution, if it's an ad hoc, because it will give right a perspective of how to take the proceedings from start from a procedural order to the last in terms of closing submissions. It's a wide range of rules, and I think it deals with every particular aspect which is there. And of course, these rules are framed under the guise of the CAC and ICC and even the MCI. So it's quite thoughtful in terms of drafting these rules, and I think it's quite advisable to put in these rules as far as possible, and of course, subject to the parties' consent. Even if one does not put it, one can always relate at the first arbitral meeting. Now, the seat of arbitration, as I said, which should be mentioned, your qualification qualifications, assuming that there is a qualification which you need to put. Seat of arbitration would determine your supervisory jurisdiction, and you may not require to put in a different jurisdiction clause. And even if you put in and no requirement of actually putting a venue, as I explained, that do not interchange your seat and venue. If you're putting one, you can only put it in terms of your convenience or holding your arbitral hearings. In the above clause, as I said, that if you replace seat with venue, so your venue will become your jurisdiction. Again, going by the judge of BGS Soma, where they say that if you do not use seat and if you use venue, then you can use that, but not to be used interchangeably. Again, just for the sake of repetition. You can put seat as X, venue as Y for holding, as I gave the example of Mumbai and Chennai. You can do it purely for convenience, but it should be clearly mentioned in your arbitration agreement. This is as I said, it will modify in terms of your commercial contracts. Now, what is the institutional arbitrations? Your institutional arbitration, I think, has a lot of advantages, as I would say, but it will again purely depend on your agreement and your particular commercial in terms of. So let's say if your dispute in nature is 50 lakhs to 80 or possibly a crore, I may or may not recommend you to go in for an institutional, because the moment you put in, even if it's in the sole arbitrator, the expenses of the arbitral institution is a little higher, and it is only for little high valued disputes. It's not that one cannot choose. I'm not at all suggesting that, but it is advisable because it will be cost effective to have an ad hoc instead of and using the rules, as I said, of IAF or IB, as the case may be. Now, what happens in institutional is there are model clauses which are there. One may just adopt it in terms of modifying it to the needs to the particular agreement. As mentioned earlier, in your international arbitrations, if you you just mention in terms of your CAC or your LCI, it is important that you mention about the seat, and you mention about the rules, and you not only forget to only mention the rules and you say that yes, my arbitration is governed by X rules, because by default then you would be leading as Singapore or London, whatever as it may be, your jurisdiction to have a supervisory about your arbitration. So your challenge, your 34 and 37 as it may be there, would be all subject to that particular jurisdiction. I think another benefit I would see in the institutional is that beforehand parties can preempt that what is the approximate amount of your fees which an arbitral tribunal will take. Let me give the example of let's say MIAC or in CIAC. You have if you go to their particular website, they have a particular sum where they mention about the amount. You can calculate your fees and you would know an approximate amount. So the example I gave of 50-80 lakhs on a crore, you would yourself realize that it is inconvenient, or it is not in the interest of the parties to have it by an institutional arbitration, and ad hoc could be something which is more appropriate in that particular case. So that's, I think, an advantage in the institutional. Again, this is a specimen of an institutional arbitration. You pick up, of course, in this case, as far as possible, as I've always said, if it's an international arbitration, have your laws and your seat and everything well defined in terms of you do not have too many where you say that, oh, Bombay here, and you have Paris, and then you say English laws. You would be only coming into various litigations. Again, party autonomy is respected and it is there within all over. But the arbitration, if it cannot come up to its clear that what law was applicable, it would only lead to complexity. So in this case, as I said, that it is governed, there's agreement and any consequences governed in accordance with the laws of Singapore, and they submit to the jurisdiction of Singapore. In dispute resolution, you say all your rights and liabilities. Here is an example where also I would take it to the mediation and the multi-tier arbitration, where I would be saying that this is an example where you say that first the parties would want to settle in 90 days. Another point there, which I missed out, that always have your settlement in a fixed amount of days. It should not be loosely worded to say that if the mediation continues, because parties would be always under the impression that yes, the mediation is on and it will go on for time immemorial, and the time to kick in the arbitration has not commenced. So always have a fixed limit. And of course, here, as I mentioned, that the rules I have taken is of the Singapore International Arbitration Center, which are deemed to be incorporated by reference. These are very important words that one has to put it within the clause so as to be abided by the institutional rules. Again, here I try to mention that if the parties agree otherwise, it should always be concerned of a single arbitrator. Now, one may ask that is it necessary that one may put that, okay, I need to put in my arbitrator, or I'll say single arbitrator, all I will decide. The example I gave earlier is that you may decide it beforehand that yes, to a next dispute, to an amount, it would be a sole arbitrator. If it's more than this, it would be Y. But in any event, even if you do not, and once you're governed by an institutional rules, as I said, those rules are so robust in nature, whether it's LCI, MCI, CAC, they will deal with every particular aspect of that particular domain. So you just leave it up to them, and then they take, once you adopt the rules from start to end, everything is then just taken care by that institution. And again, the institution is more relevant, I would feel, is that you always know that there is somebody who is looking up and is looking at your arbitration and is going to do an expedited arbitration. Unlike where we know in ad hoc, and of course, I am not saying that the ad hoc arbitrations now are not completed on time. We've noticed that, or rather I've noticed personally that there have been a change of the attitude of particular arbitrators, and matters are actually getting expedited. But still, I do not have that the fear of finishing my arbitration, of course, because 29A gives me that I can go to court and extend. And of course, now due to COVID, I will take various other reasons. But I think institutional there, because it will deal with every aspect, you're bound by that rules. I think it's very important that one can always suggest and look at drafting in terms of your in your clause. Now, there is another important aspect is the expedited procedure, which is there in, again, most of the arbitration institutional rules, where one may apply that, yes, I would want, one is of course the emergency arbitrator and the expedited procedure. The emergency arbitrator is quite in news now in terms of the Amazon issue. And but mostly everybody would have, most of the rules would have an expedited procedure where you can write. It's like let's say it's your fast track under 29B of an arbitration, of the Arbitration and Conciliation Act, where you can have an expedited procedure to complete your arbitration. And of course, parties can decide the way forward. And of course, as IBA rules of evidence, as I repeat, could be of a guiding factor, and it would expedite, and it would have a very well arbitration which is conducted in terms of the arbitration agreement. Now, these are some, it is very random in terms of giving you examples of a defective arbitration clause. These are only suggested, these are not that it covers all the particular aspect, but it is what would happen in a situation where you say all disputes arising out of the present contract shall be settled by way of an arbitration. Now, one may say that, oh, this looks a good clause. So you said intention is very clear. But the question is, when the courts will have to look at it, they would say that, okay, you say that you want to settle by arbitration. Yes, you also use the word shall. Very good. But the question is, where is your other essential features of your governing laws, your appointment mechanism, what is your applicable law, seat, venue, etc., qualification, language, as it may be. So it is subjected to see whether the court will actually refer it to the arbitration or negate this. But this is just a question which arose in one of the judgments. So I thought I will pull out this and kind of put it here in terms of a defective arbitration clause. The other example is in terms of any controversy under this contract shall be referred to arbitration under the rules of arbitration. Parties will mutually decide the arbitrator, and disputes will be submitted to the courts at moment. Now here, again, multiple issues. One, what is the rules of arbitration you wanted to be conducted? What is the number of arbitrators? You have not specified the number of arbitrators. You have also not been able to say that yes, the dispute to be referred to arbitration, or it could be in terms of Mumbai. In the courts of Mumbai should have jurisdiction. Again, little dilemma that how the court should look at it. So as far as possible, well, can avoid using such kind of clauses and be more precise, if I may put it, in your drafting of the clause. To sum up in terms of what is your drafting and effective is vague references avoided, keep it simple, not complex. May and shall specify your seat, because you need to approach the courts of that particular seat in terms of your jurisdiction. Your institutional, depending upon the quantum, as I say. One may also not restrict putting too many qualifications of an arbitrator, that he would be X, Y, he would be of such nature, this, having an X amount of degree in this, because it is very difficult. Because then what you're doing is you're limiting your, let's say even in an institutional arbitration, if you put this, what you're doing is it will be difficult for any institution to actually catch hold of some very expert in that sense of a field to have so many issues. So it would just lead to a little complications. Lastly, again, to repeat that clear and unambiguous dispute imperative, it should be drafted with a specific transaction at your hand. Avoid your boilerplate clauses. One may see in the PSUs and in these, they adopt a particular clause and keep it to say that, yes, this is the clause, but they eventually don't see that, oh, for a dispute of say 30 lakhs, I have put 3 arbitrators. Whereas for 3 arbitrators and the lawyer's fees, I would land up paying more amount of money than even claiming it in 30 lakhs, assuming if I get cost of my arbitration. Again, lighter note that a well-drafted arbitration clause is of no guarantee. But a badly drafted, yes, it will take years of proceedings and waste cost. It can be your arbitration clause, as I said earlier, it can be settled in, it will be settled in India as short as this, or it could cover every possible eventuality, my language, my nationality, my impartiality, the degrees which a particular arbitrator can have, or it could cover wide ambit. Both the extremes, in my view, should be. You should not even be too much putting into an arbitration clause, which will eventually lead to, going by my specimens. Keep it simple. Keep it in terms of where one can relay. Of course, as I said, enforcement, and this is very important. One has to look at it. That is very crucial. But and as far as possible, try to keep the laws of a same nature so as to avoid any complexity going forward. So that's the point is of an arbitration agreement and its essentials and the various. So I think I said that will place be equivalent to a seat and venue? As I said, that place and seat is something where one has to mention about it in the place and seat is, as we use it even in the arbitration, would be an equivalent, but it could not be equivalent to a venue. So do not use this interchangeably. When you say if it's a seat or if it's a place of an arbitration, mention that. Do not say seat slash place slash venue. Seat and place, yes, you can use one of them. Venue, if you have to use it in terms of convenience. Any courses in Singapore Arbitration Center offer? Yes, I mean, again, in the pandemic times, I've seen that these institutional actually come up with a few courses where they offer in terms of learning in terms of your for lawyers to be well versed with their sins. So yes, I think I have seen it, but I'm not pretty sure about it, that where exactly would you get. If my recollection goes, I think LCI had a particular thing for a brief period of time. Thank you so much.